Scope of application matters because it is the core provision of any national space legislation. It is the key clause that allows a state to determine the criteria for covering space activities and operators carrying out these activities. In national space legislation, scope of application is the tool through which we determine the application of the law to persons, to activities, and to places. It is a way to determine how the law should be applied. Countries take different approaches with regard to the different elements of the scope of application. They can choose normally among personal criteria, territorial criteria, quasi-territorial criteria, mixed criteria. The choice of these options depend on what they want to regulate and how they want to regulate their space activities. Each state is free to determine unilaterally its own national space legislation, so he can adopt personal criteria that overlap with the criteria used by other states in similar legislation. And in this case, you can have problems arising from the overlapping of this scope of application of the different laws. You can have an Australian operator launching from the territory of New Zealand. Does he need two authorizations, one from its national state, Australia, and the second one from New Zealand, from which he launches its object? This is the problem. And so the most recent legislation have introduced some ways for avoiding overlapping. A good practice can render the work of private operators easier. A state can simplify the procedures and make them more suitable for the emerging of new actors in space, startups, etc., that are involved in so-called new space economy.